The Iowa State Bar Association Committee on Ethics and Practice Guidelines offers a discussion of Iowa Ethics Opinion 13-1 Of-Counsel, presented by the Chair of the Committee, Nick Critelli.
Today, the Ethics Committee issued an opinion regarding of-counsel relationships. The opinion defines and expands the use of the relationship and gives guidance regarding the effect of the of-counsel relationship. Now, the basis for the new opinion is ABA Formal Opinion 9357 with some minor but significant modifications. So, let me introduce you to my ethics intern, Dylan Dinkla from Washburn Law School, who will explain the differences between the new and the old positions. Dylan?
Iowa's of-counsel position is found in Ethics Opinion 8711. That opinion is based upon 1972 ABA Formal Opinion 330. To qualify for of-counsel status, the relationship must include the following elements. The relationship must be between lawyers and a law firm. Law firms cannot form of-counsel relationships with each other. The relationship must be close, continuing, and personal. One could only be of counsel to one law firm at a time, and there must be regular, if not daily, contact between the of-counsel member and the law firm. In addition to these requirements, the of-counsel lawyer could not be an employee, associate, partner, or outside counsel to the firm. Also, the relationship could not be based upon referral service. In 1990, the ABA withdrew Opinion 330 and issued Formal Opinion 9357. This new opinion eliminates the element of a personal relationship while continuing the requirement of a close, regular, and continuous relationship. Also, the opinion eliminated the requirement of frequent contact. Lastly, the new opinion allows the use of firm-to-firm of-counsel relationships, as well as multiple, simultaneous of-counsel relationships. Iowa Opinion 1301 adopts ABA Formal Opinion 357, but modifies it by not limiting the nature of the economic aspect of the of-counsel relationship. This allows one to be an employee of the law firm to which one is of counsel.
Thanks, Dylan. So what have you learned? There's really only one thing to grasp. The nature of the relationship determines all the resulting ethical issues. For example, conflicts of interest, either direct or imputed, client consent, fee splitting, and marketing. The requirement of a close, regular, and continuous relationship means that everyone is considered part of one firm for all ethical purposes. As a result, in determining what you can and cannot do with reference to an of-counsel lawyer is nothing different than determining what you could or could not do with a partner or an associate. Let's take the issue of client consent. Do you need a client's consent to use the services of your of-counsel lawyer? The answer is no, unless the client has reserved the right to determine which lawyer works on the case. Now, normally, clients don't do this. They don't determine who is going to be assigned. So in that situation, you wouldn't need the consent. There are other significant changes. Under the new opinion, one law firm can become of counsel to another law firm. In essence, the two firms are considered as one. Likewise, you can form multiple simultaneous of-counsel relationships. Under the prior ABA and Iowa opinions, multiple simultaneous relationships were not allowed. But the new ABA opinion and the Iowa opinion changes all that. A lawyer or law firm may be involved in multiple of-counsel relationships all at the same time. But remember, when that occurs, everyone is considered one big firm for all ethics purposes. Now, this greatly multiplies the risk potential for imputed conflict of interest. You could easily run into a situation where uninvolved lawyers in a law firm, unrelated to a particular client or case, become disqualified because of an of-counsel link that they neither participated in or benefited from. Can it be cured by the use of a Chinese wall? Well, the answer is maybe. A third issue arises regarding of-counsel relationships with non-Iowa lawyers. Now, we struggle with the question as to whether a non-Iowa lawyer could be of-counsel to an Iowa law firm. The answer is no. The reason is simple. The foundation for the relationship is the close, regular, and continuous relationship. In order to meet the requirement, a lawyer would have to be a member of the Iowa bar in good standing. Non-Iowa lawyers or Iowa lawyers who are inactive can't meet that test. Think of what would happen if it were otherwise. 3 Supreme Court rules could easily be violated. Rule 3114 regarding pro hoc vice admission, and Rules 39.7 and 41.7 regarding retired or exempt status lawyers. Finally, a word about modern trends. Now, traditionally, the of-counsel relationship has been limited to retired lawyers who wish to continue an affiliation with their law firm. But in today's world, the relationship is much broader. It can be used to expand a law firm's services by maintaining a relationship with a prominent specialist. Both benefit. The firm gets the benefit from the specialist's prominence in their marketing, and the specialist has a captured relationship. Or a law firm wishes to test a relationship with a potential new hire. Rather than immediately entering into an associate or employee relationship, they can begin their journey as of-counsel for a probationary period. Finally, a takeaway. Choose your of-counsel relationships like you would choose your partners and associates. Use due care. In closing, I want to acknowledge the members of the committee for their good work on this. Excellent as always. For the committee, I'm Nick Critelli in Des Moines. Thank you very much.